Hello and welcome to Rajya Sabha TV. I'm Amritanshu Rai. You're watching a special report on the initiation of long-pending labour reforms in the country. After discussing pros and cons for 9 long years, a bill to simplify labour-related compliances is finally on its way to becoming a law. The Rajya Sabha passed the Simplification of Furnishing of Records and Maintenance of Registers Bill. There have been persistent demand from various quarters to simplify the forms of various returns to be furnished and registers to be maintained by the employers under different labour laws. There was also a need to expand the coverage of the labour laws to establishments employing more than 19 people.
The main purpose of this amendment is the simplification. There is no exemption to any establishments, number one. Number two, our government, led by our Honorable Prime Minister, always insisting that our main job is transparency, accountability and proper enforcement.
The proposed labour laws, simplification of procedure for furnishing returns and maintaining of registers by certain establishments Amendment Bill 2014 seeks to redefine small establishments to cover those units that employ up to 40 people from the existing limit of 19. The bill also provides for maintenance of registers and returns manually or in electronic form, and allows submission of returns through electronic mail. The law also provides to include 16 laws in place of the existing 9 laws. The compliance forms to be furnished by employers have also been simplified to 1 in place of the earlier 5 different types of forms.
The amendment bill incorporated the official amendments, seeks to give effect to those points on which consensus was reached during the tripartite consultation. The passage of the bill will extend the benefit to the simplified procedure to the establishment employing up to 40 workers in respect of return.
Whenever a new labour law was enacted, it prescribes certain registers to be maintained by the employers and also furnishing of returns of various details by the employers to the Labour Commissioner. Over the years, the numbers of such registers to be maintained and the returns to be furnished by the employers under different labour laws have increased considerably. At present, the labour laws provide exemption only to establishments employing up to 19 people, and the exemption is for 9 laws only. When the bill was first tabled in 2005, the focus was to include new technologies and enable compliance through electronic medium. Now, this bill includes recommendations of 2 standing committees on labour. After the introduction of computers in all spheres of business, need is also felt to design computer-based forms and make provision for transmitting the returns electronically. The idea is to reduce the burden of compliance on the entrepreneur.
लेबर्स के वेलफेयर के बारे में, लेबर्स के राइट्स के बारे में हमारा सरकार भी कटिबद्ध है और हम भी कटिबद्ध है, उसमें कोई कॉम्प्रोमाइज नहीं होगा. लेकिन जो conducive atmosphere for the industry also necessary. Conducive atmosphere for the industry also necessary, because whenever the more production comes, more employability will come. So that's why my humble request is to see on this consultation.
Okay. We should see that penalty clause and some strict measures as far as the defaulters are concerned. Those who are not adhering to the law, new elected law, if these things are taken care of, I think things would be good and the economy will progress the way it is sought by the NDA government.
The first time this law was introduced, the goal was to expand the coverage of the law to establishments employing up to 500 workers. That may not have been feasible, but adapting to the law to technology remained as a need. The present bill proposes simplified user-friendly forms for maintenance of registers. These records can be maintained manually or in computer floppy, diskette or other electronic media and can be produced as and when required.
In this bill, which you are diluting or simplifying, now there is a provision of display all the things, whatever report they are submitting in a public place inside every workplace. And out of that, then worker came to know what is in display, whether his name is in register or not. And most of the places it is being violated. And because of that, even after the accident, worker dies, when employer says he is not in my role, nobody can challenge because nothing is displayed. Already they are violating. Now on this present system, in the name of simplification, you have done away with the position of that provision.
No, it's clear.
Without that display provision, if worker does not know, and say in a public sector they can get it know by RTI, but private sector no obligation under RTI. Then how they will come to know workers that his name is there in register or a proper registration? So how do you address this? And you are still telling that you are not.
Don't repeat. You said it. It's clear.
Actually, in the name of simplification,
Don't
that
repeat.
is being done.
So ये definition itself will be very damaging to the working class of these people, this country, sir. It is to be withdrawn. It should not be accepted.
These are the times of undependable employment. We are passing through such times that the particular private sector, corporate sector cannot assure employment not only to the lowest of the low, even to the highest of the high. But let us not forget the productivity of labor is not only an essential condition for the prosperity of enterprises, but also basis for the sustenance of the workers and their families. If we visit any industrial establishment or any project site, the condition of the contract employment is so pathetic that we can see the pathetic India besides sustained India. It is glaringly exposing that we are yet to include. At such these situations, what is labor welfare? Whether you like it or not, the labor welfare is the critical dimension of industrial relations, and it is integral part of social security.
Medium and large enterprises, establishments should not enjoy the benefits which are given to the small establishments.
Thank you.
Sir, just 1 minute. So it has been recommended by the standing committee that the status quo must be maintained, or it may be at the least raised up to level, but 25, but it sticks on to 40. Some amendments have been given by my comrades, colleagues, Mr. Tapan Kumar, my Rajya and all others, that it should be come down to 14. Whereas another amendment by Mr. Vivek Gupta, which sounds sensible, says that, sir, if the small establishments have a turnover exceeding rupees 10 crore, the exemption from furnishing the returns or to maintain the registers required to be furnished or maintained under the Scheduled Act shall not apply to them. Sir, these two things, that the number of employees which are in an establishment should not exceed 19, or at the least it could be
please conclude.
Increased to 25. And if the turnover exceeds 10 crores, they should not come under the small establishment. This is the only one thing, sir, which is disturbing, and other things in this bill ought to be welcome.
Mr. Satyanarayan Jatiya, please.
By the Minister. Thank you very much.
The Second National Commission on Labour had recommended that in view of globalization and liberalization processes, certain changes to the existing legal structure be made. The present bill is in line with the recommendations.
यह कानून जो आया है एक लंबे रुकाते हुए चल करके यहाँ तक भी पहुँचा है, परंतु यह आखिरी बात नहीं है। ये शुरुआत भी नहीं है, क्योंकि हमने इस सारी बातों को करने के लिए बहुत पहले से सारी बातें की है। और इसलिए मेरा कहना है कि हमें प्रतीक्षा करना चाहिए कि हम श्रम सुधारों के बारे में, जिसको हम लेबर रिफॉर्म्स कहते हैं, उसके बारे में सर्वांगीण रूप से विचार करें, मजदूर का विचार करें।
It's time for us to head into a break. When we return, we will tell you more about the recommendations of the Standing Committee. Welcome back. All the amendments that were carried out in this bill were the amendments proposed by the Standing Committee. Also, this bill is the same bill that was introduced by the UPA government in 2011.
The Standing Committee on Labour submitted its 21st report on the then labour laws exemption from furnishing returns and maintaining registers by certain establishments amendment bill. The committee felt that the Ministry of Labour needs to reconsider the proposed amendments in order to secure the rights of the workers in light of acute manpower shortage in the office of the Labour Commissioner. The attempt was to reduce the burden on the Labour Commissioner.
ये सरकार हम कभी भी वर्कर्स के इंटरेस्ट को हम बराबर जो है प्रोटेक्ट करेंगे और बराबर जो है नए मंत्री के नाते से उनके राइट्स को प्रोटेक्ट करने की जिम्मेदारी हमारे पास है.
The Parliamentary Standing Committee suggested that the name of the bill be changed to Simplification of Procedure for Furnishing Returns and Maintaining of Registers by Certain Establishments Bill, which the present government accepted. The committee noted that the date of submission of annual returns is January 31st of every year. It recommended that the date be changed to March 31st so that there is uniformity on the date on which establishments need to submit returns. The government accepted this change. The committee recommended that till the organizations that maintain the information furnished by the small establishments are fully computerized, the information may also be kept manually. The government also accepted this recommendation.
जितने भी इस नियम के अंदर ये जो कानून बने हैं, ये टोटली सार्वजनिक लेबरों के हित को ध्यान में रखकर बनाए गए हैं. इस दृष्टि से मैं इस बिल का स्वागत करता हूं.
Public is generally has some high expectation from the government. This government is bent upon dismantling that structure for the exclusive benefits of the predators of the economy.
Who are the real backbone of this democracy? They are the peasant class. They are the labor class. For them we are here. Whatever has been said, whatever you want to make modern India into go into the world as a number one. Who will make India? It's only by the laborers.
You want to help the industrialists, the factory owners, the capitalists. I put it in general. And you are not interested in protecting the interests of workers, the laborers. That is what we are saying. Why can't you reduce? My comrade, colleague Tapansan said the productivity is increasing every day. Science and technology grow, productivity increases, and now it has brought tremendous changes in the labor process, and thereby you should reduce from 19 to say 14 or say 10. Even Sadish Chandra Mishra said, why can't you make it 10? But you are making it 40. For what? To help whom? These are the questions you will have to answer, sir. These are the questions you will have to answer. That is why we are not in a position to agree with you.
I am quoting, in the given circumstances, committee are apprehensive that further increasing the number of employees would entail most of the industries being exempted from such and such. Then mindful, please note, that is the relevant portion, mindful of the stout opposition from the majority of the trade unions. This standing committee unanimously recorded after seeing the deposition of the trade unions, which were called in the standing committee as witness to record. Even after that, if your file records there is a majority consensus, should You relied on which? This
All right.
or your file recording? This is number one.
Mentioning that the majority was in the consensus and accordingly the further necessary action be taken for amendment of the bill. So this is the minutes of this meeting. That's why I don't want to go into much dispute.
According to a World Bank report in 2008, heavy labor reforms would be desirable. The executive summary stated, India's labor regulations are among the most restrictive and complex in the world. This has constrained the growth of the formal manufacturing sector where these laws have their widest application. Better designed labor regulations can attract more labor-intensive investment and create jobs.
There were some amendments of the Standing Committee that the government did not accept, as accepting these amendments would have changed the fundamental of the bill. Let's have a look.
The committee felt that since the turnover of high-tech establishments with a lesser number of employees may be high, many large and medium industries will be converted to small industries. So no change to the definition of small establishment should be made. But the government differed with the recommendations.
What has been happening in this country for the last 20 years. We want to progress. We want to progress faster. I think we must look at modernization of labor laws.
लेबर ओरिएंटेड की बात हम कर रहे हैं, लेबर के हक की बात कर रहे हैं. इसमें इतने एक्ट्स आपने डाल दिए हैं शेड्यूल में जिसमें ऑलमोस्ट एवरी एक्ट इज इंक्लूडेड व्हिच कंसर्न्स द लेबर लॉ, एंड nothing remains after these 16 acts. And these labor persons who are working under this, they are the persons who are getting the most meager wages. Most of them are not paid the minimum wages. I had the opportunity to contest a large number of cases on behalf of the laborers, and they can't even afford lawyers because they have to first go to the tribunal, labor tribunal, then they have to go before the labor officer and labor tribunal, then the high court, then the Supreme Court, which is impossible.
ठेकेदारों के उन व्यापारियों के हित के लिए बनाया है. मास्टर रोल जो बनते हैं आज भी, जितने भी सरकारी गवर्नमेंट के विभाग हैं उनमें मास्टर रोल बनते हैं. हाथ पैर का अंगूठा लगा करके नाम किसी का भर करके पैसा निकाल लिया जाता है. एक्चुअल मजदूर जो काम करने वाला है उसका कहीं नाम नहीं रहता, उसको कोई लाभ नहीं होता है. उनका इसमें अगर जिक्र होता तो हम बधाई देते सरकार को, लेकिन ये सरकार मजदूर विरोधी है.
The committee recommended that penal provisions be added so that actions could be taken against establishments that do not furnish returns, and this would act as a deterrent. But the government felt otherwise.
There is no exemption of anything in this matter. But on the other hand, the transparency, as I mentioned, transparency, accountability, and also the enforcement, these three things will be taken care of, and the workers' interest also will be safeguarded. That is my contention.
The committee found that there is shortage of manpower with the Office of the Labour Commissioner, which is the enforcing authority. It therefore recommended that adequate and efficient human resource be put in place for strengthening of the enforcement machinery.
Thank you for watching this special report. We'll be back with a new issue and a new report. Keep watching Rajya Sabha TV.